Hello everyone, I'm Saumya. I'm a chartered accountant and a company secretary. So today I am here to discuss June 2021 attempts JIGL question paper. So what is the objective or what are the benefits that the students are getting by discussing this question paper? There are two benefits. The first one is if you have already prepared, that is your exams are fast approaching, it's in hardly in another 15 days. So if you have already prepared for your exams, that is you completed all the chapters and revision everything, then by going through this question paper, it acts as a confidence booster. So you can, by looking at the questions, you feel that okay, I can also answer. So I know this question, I can't answer this question. So that it acts as a confidence booster. And the second benefit is if you have not yet completely prepared, maybe few topics here and there, spillovers you have not yet completed, then it acts as a check on your preparation. Okay, so you can just you will get an idea like, okay, this is the area where I need to concentrate more, this is the area where I need to this is a topic which I need to concentrate more. So that acts as a check on your preparation. So it is for both those who have already prepared or those who are still preparing, maybe a few chapters, few topics, if it is pending, then for you also it acts as a check. So with this, we will start discussing June 2021 attempt JIGL question paper. See, one more thing about this paper is, if you take other subjects, it says like exactly part A is for 40 marks, part B is for 30 marks, like that some bifurcation you will get. But in JIGL, this is the, we can call it as maybe a slight disadvantage, wherein we cannot exactly tell what is the, I mean, like from 1 to 6 chapter it is 50 marks, 7 to 10 chapter it is 20 marks, like that we cannot bifurcate and tell. All the 17 chapters are equally important and you need to prepare for all the chapters, keeping in mind all the chapters are important. So it is like that. So with this much of knowledge, I think we can start discussing the paper. So first we will see how many questions are there, and whether you get any what do you call alternative options or all these things. So first thing is, see, we all know this is the paper, this is paper 1, and the maximum marks is 100, and you have 3 hours time. Then total number of questions is 6. So that means what? You are getting 6 main questions. Okay, 6 main questions. In that, in second question and sixth question, you are getting an alternative. That means you get an option, choice. You have a choice. Okay, there will be a subsection, sub question 2 and 6. You have the option. So I'll just show you. See. So you come to question number 2, it says answer question number 2 or 2A. So you have an option here, either 2, that means all the questions of 2 or all the questions of 2A you need to answer. Then when we go to 6th question also, you have an option. So that means what? For 2 questions, you have an option. You can choose anyone. But apart from that, there are no choice, nothing. So all the questions, all the 6 questions you need to attempt. Question number 2 and question number 6, you have an option. That means alternative questions are available. So whichever set you want, set 2 or set 2A, whichever question, whichever set you want, you can opt for that and you can answer. And see, first question is 5 marks each. Okay, first question contains 4 questions. First main question contains 4 sub questions, and each question is of 5 marks. Okay, each question carries 5 marks. And after that, if you see all the other questions like 2, 3, 4, 5, 6, it carries 4 marks each. Okay, 4 marks each. But again, one more thing is only question number 5. Only question number 5 carries 8 marks. So that means you are having, instead of 4 into 4, in question number 5, you have only 2 questions of 8 marks each. Okay, so what and all we have understood, 3 important points with respect to the whole paper. The first point is you have no options. Okay, all questions are compulsory. But when you come to question number 2 and question number 6, internally you have option. That means you have two sets of four questions. Whichever set you want, you can opt for it. Either you can go for 2, answer all the questions of 2, or you can opt for 2A and answer all the questions of 2A. Same thing in section, same thing in question number 6 also. And first question carries 5 marks each. So first question is again divided into 4 questions, sub questions, and each question carries 5 marks each. But all the other questions carries 4 marks each. Again, when it comes to 5th question, it carries 8 marks. So in 5th question, we have only 2 sub question instead of 4. Why? Because it is 8 marks. It's not 4 into 4, it is 8 into 2. So these are the few important points which I wanted to clarify before discussing the paper. So with this, we will start with the first question. So question number 1A, that is, discuss the main feature of statutory corporation under administrative law. So this is administrative law is your chapter 5. So we have to discuss about statutory corporation. So statutory corporation means what? It is a corporation which is established, or it is like a body corporate which is established under a separate statute or a special act. So that is statutory corporation. So features you need to write. So see, this is for 5 marks. If you write 6 to 7 features, that will be more than sufficient. Just you can answer the, you can write the points. So if you see the guideline answers given by the institute, it says like this: the main features of corporation, statutory corporation are, it's incorporated under a special act of parliament, then it is an autonomous body and free from government control. So like this, you can write the points. So basically you're explaining the main features of a statutory corporation. So this is it's a 5-mark question. So institute expects you to write something extra. So don't stop exactly 5 marks means don't stop at 5 points, write 6 to 7 points. But if that, if the topic itself contains 4 points, or if the topic itself contains 5 points, we can't, expand that answer. We can't do it. But if there is like 10 points are there, and if the question is for 5 marks, try to write 6 to 7 points. So that is with respect to 1A. So this is a very, direct question, easy question. Then next we will go to 1B. This is like a scenario they have given. We will try to understand what they are expecting. Why Vijay, an accused, committed an offense of dacoity in 2015. At the time, dacoity was punishable with 10 years of imprisonment. So at that time in 2015, dacoity was punishable with 10 years of imprisonment. Then in 2016, during his trial, a law was passed which made dacoity punishable with lifetime imprisonment. Which penalty would be applicable on accused Vijay? Discuss the answer with respect to Article 20, subsection 1 of Indian Constitution. So this is 21 is related to ex post facto laws. So what was the law when the act or a offense was committed? That law, that punishment only you have to take, not the one which changes later during the trial or during the judgment. If the law has changed or if the punishment or anything is increased, that we are not considering. On the day when this offense was committed, what was the law, what was the punishment, that is what we have to consider. So retrospective effect and all we are not supposed to consider. So that is what is given. That is the question they are asking. So with respect to ex post facto laws, as we have already studied, we know that only in ex post facto laws, we are considering the punishment on the date of committing of the offense, whatever was a punishment, whatever was the law, that we are considering, and not the one which comes later. So there can be any change in law. See, for judgment, for trial and all, it might take like 2 or 3 years. In 2 or 3 years, the law would have changed. That's okay. We are not considering that. What was the law on the date when the offense was committed, or the when act has happened? That's all. That law you have to consider, and you have to give the punishment accordingly. So there is no retrospective effect for a criminal offense punishment and all. So that is given under 20 subsection 1. So that you have to explain. So that is 1B. So this is also we have already discussed in class, and so that depending on 21, whatever is given in ex post facto laws, that you have to first write the meaning of ex post facto laws, and then you have to explain this scenario, and then you have to write a conclusion telling, see, ex post facto laws means this. So from the above discussion, it is clear that So what is the conclusion? What is conclusion? In 2015, whatever was the punishment, that is a punishment we are going to give to the accused. Okay, so that is again a simple question. Next we will go to C. That is, natural law says that certain rights are inherent by virtue of human nature and can be understood universally through human reason. Explain. So this is with respect to natural school. Okay, they are asking with respect to natural school. See, basically we have already learned what natural school says. Natural school says what is dharma, what is adharma, what is justice, what is injustice. So it is all within our human what do you call, human nature only. So nobody from outside, we don't want any legislature, we don't want any government to come and tell whether what we are doing is correct or not. It is there inherent, it is there within only. Correct. So that is natural school. You are explaining this about, you know, 1 or 2 lines you explain about the natural school, and then you write 1 or 2 definition. That one line definition is sufficient. Okay, so that definition you will be writing. That is, if you take Justinian's Digest definition, it says the standard of what is just and unjust. And you can write Cicero definition, that is the highest reason implanted in nature. So like this 1 or 2, just 1 line definition you can write, and you have to write, you have to little elaborate about it. What is that your elaboration means? It is in your own words you are telling, see, this natural school talks about the dharma or adharma, justice, injustice, whatever you call it as, right and wrong. Basically it says that we don't need any outside agency or someone else, third party, to come and tell what I'm doing is right or not. It is human nature, it is inherent, it's like inbuilt, it's there in our system only, it's there in our brain. We will know what we are doing, whether it's right or wrong. So we don't want any outsider to come and tell whether it is right, the action whatever I've done is right or wrong. So this little explanation in your own words, whatever you have understood, that explanation you can give, and then come to solvent. Okay, solvent we have already discussed in class. So with solvent definition also you can write and explain a little bit. So this is sufficient for 5 marks. This is sufficient. So you are explaining about natural school, you are giving 1 or 2 definitions, that's just 1 line definition, and then in your own words you are explaining what about the natural school, what basically natural school, what they believe in. So that you are explaining, and after that you are giving some information about solvent theory. That's all. You can end your answer. So that is what is that they are giving. See, understand the question. Natural law says that certain rights are inherent by virtue of human nature. That is there in our nature only. It's human nature. So no, we don't want an outsider to come and tell us, and can be understood universally through human reason. So that about natural school you are writing. So that explanation is sufficient. Then we will go to the next question, that is, what is meant by tribunal? Explain the object of tribunal. So tribunal, we have had a good discussion in class. So you are writing meaning of tribunal. So it's a quasi judicial body. So all these things, tribunal, you have understood. So you can write a few sentences in your own words about a tribunal, and then you explain those 2 important objects of tribunal. What is that? First one is to reduce the mounting arrears in high courts and to secure speedy disposal of cases. So that you can elaborate a little bit and you can explain those 2 objectives. So this answer is expected from 1D. So this is your question number 1. Next we will go to question number 2. So question number 2, as I already told you, you will have 2 sets of questions. 2 contains 4 questions. Again, 2A has 4 questions. So whichever set you want, you can. So it is not like from 2 you are writing A and B, from 2A you are writing C and D. It's not like that. Either you have to completely write 2 answer, that is 2 A, B, C, D, or 2A, A, B, C, D. So whichever set you want, you have to write it completely. So first we will see 2. Whether in case of consent and compromise decree between parties, principle of res judicata shall apply. Discuss. See, res judicata, it's very, res sub judice and res judicata are 2 important principles which you should know. So we have already discussed, and one more thing what we have already seen in classes, we have understood that in case of consent and compromise decree, this principle will not be applicable. Res judicata will not be applicable. So how you are going to answer? First you write what is principle of res judicata. Okay, first you have to explain what is the principle of res judicata. So it is like no one shall be vexed twice for the same cause. So we also know that, however, it does not apply in case of consent and compromise between parties, but it depends on the court subject to the facts of the case. See, usually normal what happens is, first what you are writing, first you explain what is res judicata, because the person who is evaluating your answer, he should know first whether you have understood what is res judicata. So first you have to write what is res judicata, and then you explain to consent and compromise decree. This res judicata will not be applicable. In general, we know that it is not applicable, but it depends on facts and circumstance of the case. So that explanation you need to give. So first you are explaining for 2 marks, you are explaining about res judicata, and then you are explaining whether this is applicable or not. Next, to constitute a tort, there must be a wrongful act and legal damages. Explain. So this is a very simple question. You here you are explaining what is the wrongful act, what is legal damages. Okay. In under legal damages, you are also explaining 2 important maxims that you should not forget. Okay. Just because it is for 4 marks, just don't write wrongful act, meaning, and legal damages and end your answer. So you need to explain damnum in injuria and injurious in damnum. So those 2 are very, very important. Then coming to the next question, explain the term receipt under Indian Stamp Act. So if you remember, we have already discussed, like receipt, you need to take receipt for promissory note, a bill of exchange more than 500 rupees. So the person who has paid, who has paid the money or who has issued a promissory note or bill of exchange, he should demand from the person who is receiving to give a receipt. It's like an acknowledgement. So what and all constitutes a receipt, or under what circumstances you can demand a receipt? So that we have already discussed. So those four, 5 points we have discussed. So that if you write, that is sufficient for this answer. Then next one is discuss the importance of illustration. See, illustration also in interpretation of statutes. In interpretation of statutes, if you remember, we have discussed about illustration and explanation. So it is one of the internal aids. So that illustration and explanations, you can write like just 2 paragraphs. It's a small answer, so you can just write about illustrations and explanation, and you can end the answer. So that is for 4 marks that we have already had a discussion. Interpretation of statute. So that's again a direct question. Next, discuss the aim and objectives of General Clauses Act. So what are the aim and objectives of General Clauses Act? So General Clauses Act means what? It is like a law for all the laws, correct? So for giving uniformity of expression, and if they're in any law, if they say like he should be punished or she should be punished, we say that masculine includes feminine, singular includes plural. So like this, for giving uniformity of expression and to give a set of definitions which is in general, which is applicable to all the laws. So these are some of the objectives and importance. So it's the aim of General Clauses Act that we have already discussed in class. So same thing you can write. That is also for 4 marks. This is we are discussing 2A. So the next set. The next question is, the decision of a court allowing a suit which had been instituted after the period prescribed is not vitiated for want of jurisdiction. Discuss it in the light of provisions under Section 3 relating to bar of limitation under Limitation Act 1963. So this, you have to explain Section 3. So what you have to write, you have to say that any suit appeal application, if made beyond the prescribed period of limitation, it is the duty of the court not to proceed with such suits, irrespective of the fact whether the plea of limitation has been set up as defense or not. The provisions of Section 3 are mandatory. The court on suo motu can take a note of the period of limitation, and the question whether a suit is barred by limitation should be decided on the facts as they stood on the date of presentation of the plaint. It is a vital section upon which the whole Limitation Act depends for its efficacy. So the effect of Section 3 of the Act is not to deprive the court of its jurisdiction. Therefore, the decision of a court allowing a suit which had been instituted after the period prescribed is not vitiated for want of jurisdiction. A decree passed in a time-barred suit is not a nullity. So why I am reading the whole answer? This is given in guideline answers. This is the answer which is given by your institute only. That is what I just now I read. See, here you need to divide your answer into two paragraphs. Okay, it is a 4-mark question. You need to divide answer into two paragraphs. The first paragraph talks about section 3. Section 3 is a mandatory section. That is what you have to write. Okay, section 3 is mandatory section. So what we have to tell, when a case is filed, court on suo motu, that's court on its own, should not entertain the cases. Okay, these kind of time barred cases, court should not, when the prescribed period of limitation is over, it has expired, court should not entertain these kind of cases. Okay, so, and when the case is filed, whether the other party talks about prescribed period of limitation or not, court on its own should not entertain the cases. Okay, court should tell, no, I'll not take up this case because it is the time period is expired. So this is what is expected from the court. But so this is what you are writing in first paragraph. In the next paragraph, you are telling, however, if court on its own, if it does not if it entertains the case, that is, if it does not dismiss the case, then if a decree is passed by the court, that decree will never become invalid. So even though, see, first thing is court should not entertain the cases. Yes, court will not entertain that case which is time barred. Okay, that is court suo motu will tell, see, this is a time barred, so I don't want to take up this case. This is what court says. But by chance, if court accepts and it passes a decree, later the decree will not become invalid. So that you are telling in your second paragraph. Okay, that is, these two things are expected from you in the 2A2 question. Okay, so these two things you have to write. What is that? The first paragraph you are talking about, what is section 3? Section 3 is a mandatory section. So court should not entertain such cases. All these things you have to write. And then the second paragraph you have to tell, even though if the court in certain circumstances, if the court by mistake, if it has accepted and if it has passed the decree, then decree will become valid. Even though it was time barred, that's fine. But decree, once the court passes a decree, it becomes valid. Okay, later you can't tell this decree is not having any value. It is having value. It is valid decree only. It will not be made invalid. So that is section 3. This is what you have to write. Then discuss important forms of mens rea. So this we have already discussed in IPC. That is intention, then negligence, recklessness. So here what you have expected is, first you have to tell what is mens rea. Okay, the guilty mind, all these things, some 1 or 2 sentences. First you explain what is mens rea, because they are asking forms of mens rea. Now first you write what is mens rea, and then you write 3 forms of mens rea. Okay, intention, recklessness, negligence, all these things. So that is your 4 marks. So first point you are explaining what is mens rea, then you are explaining the forms. Then we'll go to the next one. So explain the requisites of a warrant of arrest. So arrest warrant we have already discussed in CRPC. So then what is the time limit within which the police officer should bring the person arrested before the court? So we know this is 24 hours, excluding the time of journey and all those things. So that is a time period within which you have to produce the person to the court. Then warrant of arrest, so many requisites are there, so which is given in second schedule. So we will see what are the requisites of a arrest warrant. That is, it should be in writing and it must bear the name and designation of the person who is executing it. Then full name and description of the person to be arrested. Then what is the offense? Then it should be signed by the presiding officer and it should contain the seal. So all these are requisites. So this you have to write these points. So you should not miss any point. All the points you have to write, and you have to write the time limit also. So don't forget, because the question does not only it's not only talking about the requisites of a warrant of arrest, it is continuing, they are also asking what is the time limit, so that you should not forget. So requisites you are writing point wise, and then you are also writing the last paragraph, you are also writing, that is 24 hours. So you have to elaborate the answer. This is just, I'm discussing the question paper, I'm not just telling 24 hours, but you have to write properly. So that is 24 hours exclusive of the time necessary for journey. So all these things you have to write. So that is your second question, 2 and 2A. Next, we will go to the third one. When the opinion of any person is relevant except experts under Indian Evidence Act 1872. So when the opinion, so apart from this, when the opinion of any person is relevant except experts under Indian Evidence Act. So apart from experts, other person's opinion will also matter. Under Indian Evidence Act, we will consider what are those opinions, who are those people. So that is asked in your 3A. So it is like, if you see, it comes under 47A, all those things. So opinion of handwriting, opinion as to handwriting of a person, then digital signature. So we will be going to the certifying authority and taking his opinion to see whether this digital signature is original or fake. Then opinion about a general right and custom. So all these things are there. No, apart from experts, we will also take opinion of other people. So what kind of opinion we will take, from whom we will take. So those points you are writing. Okay, expert opinion anyway, everywhere we find, we will take it, that we all know. But apart from that, there are also opinion of other people which matters a lot, which acts as an evidence according to Indian Evidence Act 1872. So what are those opinions? Who are giving that opinion? So that is what they are asking in 3A. So those things you have to write, that is handwriting, then digital signature, then rights and customs. So all these things you have to write. Those points you have to write. Then explain interim measures explain the interim measures of protection for which a party during the arbitral proceedings may apply to the arbitral tribunal under section 17 subsection 1 of Arbitration and Conciliation Act 1996. So this talks about interim measure. So interim measure means the award is not yet passed. So before that, you want some relief, you want a measure, you want or some remedy. So then you can apply to the tribunal and you can get it. So what are those interim measures? So what are the protection you want to obtain? So that those points you need to write. Like, like if the person is minor or of unsound mind, you want some guardian to be appointed. So that those things you have to see. Here they are asking 17.1, that is you're asking interim measures, or you're taking the protection from tribunal itself, arbitral tribunal itself. You're not going to court. So that is different section. That is a different section. So here they're asking how you take protection, as under interim measure, how you take protection from arbitral tribunal only under section 17 subsection 1. Okay, that is those points you have to write. Like if you want to secure some amount in dispute, or you want to secure some goods. So all these things, those points you have to write. And this is also a direct question. So next, who can present documents for registration at the proper registration office under Registration Act 1908? So this also, if you remember, we have had a detailed discussion about who should present the documents for registration. See here, one more special point what you have to add in this particular answer, that is 3C, is if they ask like who are the people who can present the documents for registration. If you just say like some person executing and claiming under the same, or authorized representative or agent, so all these things, anyway these three people can go, they can present the documents for registration. This you write these 3 points, that is authorized representative, or representative or assign of such person, or the agent of such person. All these things, 3 points are there, that we are we know that is section 32, we will write. But apart from that, you also have to write 2 more points. What is that? See, first thing is special power of attorney. You need to talk about that. You need to write. So that is special power of attorney is required. Like normal GPA, if you give, but this Registration Act, that is not applicable. Okay, normal GPA is not applicable for registration. Specifically, you have to give one special power of attorney. Okay, that you have to write. Next one is, next important point what you are writing is whether the document requires compulsory registration or not. The person who is authorized under section 32, only those people only can go and get the documents registered. So just because, see, for example, some document for which registration is not required, okay, it's not compulsory. Say only to be on safer side, I am getting it registered. Just because the document does not require compulsory registration, I cannot appoint someone who is not mentioned under section 32 and ask him to, I can't appoint him and ask him to go and get it registered. That is not possible. So whether the documents requires compulsory registration or not, when a person is going for getting it registered, when a person is appearing before the registrar for getting the document registered, he has to be a person who is mentioned under section 32. apart from those three people whom we saw, no, though, apart from those three persons, no one else can go and present the document for registration. Otherwise, the registration will be invalid. Okay, that those 2 points you have to write along with these three. Section 32 3 points anyway you are explaining, but these two are special things which you have to remember. These special points also you have to write. Then only your answer will be completed. Okay, so those two things you need to remember. Then 3C, that is who can. Sorry, this is done. Then 3D. In RP Limited versus Indian Express newspaper, if you remember the Supreme Court decision, we have already seen in Right to Information Act. RP Limited versus Indian Express newspaper, the Supreme Court read into Article 21, that is right to know, discuss how right to know is related to right to information under Right to Information Act. So this is a very what do you call, just one paragraph answer. It's a very small answer. It's not lengthy, but the thing is you need to explain. Here you are explaining a little bit about Article 21 also, and you are explaining about right to information also. So you are giving the details of both. So you need to mix your Right to Information Act also, your Indian Constitution knowledge also, and you have to write an answer. So they are not expecting very much, elaborated answer and long paragraphs and all. Just they want to know how much you have understood. So you are going to give a link between this Article 21 and Right to Information Act. So I'll just read out what our institute has given the answer. That is guideline answer, what our institute has written. So here what Supreme Court says is, Supreme Court held that right to know is a necessary ingredient of participatory democracy. If you remember in our notes, in the introduction, few points I have given. So that is what those points only you have to write here. Okay, those points only you have to write here. I'll just read out. See, the Supreme Court held that right to know is a necessary ingredient of a participatory democracy. So in a democracy, this right to know is very, very important. And in a view of transnational developments, when distances are shrinking, international communities are coming together for cooperation in various spheres, and they're moving towards global perspective in various fields, including human rights. Expression liberty must receive an expanded meaning. The expression cannot be limited to mere absence of bodily restraint. So here, this is something which you need to explain. See, when we talk about liberalization, globalization, and all those things, it is like in liberalization, globalization, if you see, our government is giving us more powers to the individuals or private people, that is general public, to carry on the business with other countries more easily, more conveniently. Correct. So this is related to transnational developments. That is, with other nations also we are entering into contracts, we are entering into a lot of businesses. So all these things are happening. That is there. But Supreme Court, what it pointed out is, in this case, it also told, see, this is not just bodily restraint. Bodily restraint means, so in liberalization, if you take LPG, the government told, see, you can easily carry on business with other countries and all those things. We can, I can go to other country, I can start my business. Other country business persons can come here and start their business easily. So that is fine. But this expansion or this whatever the power, whatever the liberty they are giving, it is not just for the physical liberty, that is going there, starting the business and all those things. It is also, it should be expanded to getting information about what government is doing. Okay, so this globalization, privatization, whatever transnational development, whatever our country is developing, we are entering into contracts with other countries. Correct. All this, so many barriers are removed. All these we will accept, but it is not giving us a complete meaning. So to complete it, what we have to do, it includes right to know also. So this development should happen in such a way that as a businessman or as a general public, if you want to know what government is doing, what information they are having, that information you should also get it. Then only we can call it as a, all over our country is developing and all those things. This is what Supreme Court pointed out. So this you have to write. So the liberty must receive an expanded meaning, and the expression cannot be limited to mere absence of bodily restraint. So it is wide enough to expand to full range of rights, including right to hold a particular opinion and right to sustain and nurture that opinion. So if you are having some opinion, you can sustain that opinion. So you can See, if you feel that this, for a particular construction of bridge or a road or anything, if you feel that the government is not using the proper materials or anything, you can go take a sample. How you can do it? Because you have a right under Right to Information Act. So that is nurture that opinion. So for sustaining and nurturing that opinion, it becomes necessary to receive the opinion. So receive the information. So if you just have opinion, how you are going to sustain, how you are going to prove that your opinion is right? How you can prove by getting the information, proper information. So because of right to information, now you have a right to visit the government department, take whatever information you want. However, there are certain restrictions apart from that. So how government how government departments are working, what information they are holding, what information you want, you can ask them, you can take it anytime. So this explanation you have to give in this is what they are expecting in 3D. Okay, this you have to write. So that paragraph, everything you have to write. So the globalization, whatever transnational development is not related to only bodily restraint, absence of barriers, only not that. So if you are having any opinion, you can sustain and nurture it. So how do you sustain and nurture an opinion? By getting right information. How can you receive the information? Because of this act. So this is just one paragraph answer. So these things you need to include and write. So this is like a kind of little general question they have asked. They just want to know basically how much you have understood about the topic. That's all. So next we will go to fourth. So explain the procedure for obtaining electronic signature certificate under Information Technology Act 2000. So here, please don't get confused when they ask electronic signature. Don't start writing second schedule and all those things. Okay, they are asking digital signature certificate. But see, if you remember in the Information Technology Act, when we discussed the Information Technology Act, I have already told you electronic signature means it is like it has a broad meaning. It has a lot of things under you have so many things coming under electronic signature. Under that, digital signature is also one. So digital signature forms part of electronic signature. So if they give electronic signature certificate, please read the question properly and then start answering. So the moment you see electronic signature, don't start answering or writing about electronic signature, because they have included certificate also here. They are asking about DSC, digital signature certificate, like that you have to consider it as DSC and you have to answer. So don't get confused. So they are asking procedure. See, for electronic signature certificate, we don't have any just normal electronic signature. We don't have any procedure and all. And we are obtaining means it is digital signature only. So that kind of confusions you should not have. You should be very clear when you are reading the question. So the procedure of obtaining electronic signature certificate they have asked. So that procedure is you need to make an application in the prescribed form. You need to pay the prescribed fee. So many 3-4 points are there. Those points, if you explain, that is sufficient. And at the end, you also have to tell no application shall be rejected unless applicant has been given a reasonable opportunity to show cause. Okay, so those things you have to consider. And the next one is very easy. Requisites of a valid custom. So essential conditions of a valid custom. Explain any 4. So if you want, you can write 5. Okay, because they have only asked for just 1 extra. You can write. Need not write all the points because you have to manage the time also. You have only 3 hours and you have to answer so many questions. So you have to manage time. So you can write just 1 point extra because they have only asked you only write any 4. So you can write like certainty, reasonableness, then unanimity of opinion, peaceable enjoyment, consistency. So all these things we have already discussed. So many points are there. 7 to 8 points are there. So if you can write any 4 or 5, maximum 1 point extra you can write. Then any law which is inconsistent, say the 4C, any law which is inconsistent with the fundamental rights is void to the extent of inconsistency, and it is not necessary to strike down the whole act as invalid if only a part is invalid. Explain or discuss. See, this is related to the question. This is related to the doctrine of severability. Doctrine of severability. So that is, if you remember, justifiability of fundamental rights. Under that, we have studied 3 doctrines. Correct? Doctrine of severability, eclipse. So waiving off. So all these things we have studied. No, so in that first one is doctrine of severability. That is when you can separate any act which is inconsistent with the fundamental right. If you cannot separate the valid and invalid part, the whole act will become invalid. Otherwise, if you can separate, that is, if you can filter it out, only the valid part will continue and invalid part will become void. So this you have to explain in 2 to 3 paragraphs. Okay. Just first you explain doctrine of severability, and then you tell, see, if it can be separated, the valid part will continue. You can feel it's like filtering it out. The valid part will continue. That is the part which is consistent with the fundamental right, that particular provision or act, that will continue, and the invalid part will become void. So this in detail you need to explain what is doctrine of severability, and you need to explain this sentence also. That means whole act need not become invalid. See, just because one point, see, out of, if an act contains, just assume if an act contains 20 points, only if one point is not consistent with the fundamental right, only that point you delete. Other 19 points are valid. No, that will continue. That will continue. That will be valid only. So that you have to explain in 4C. Then 4D, if the intention of the legislature is not clear, there are presumptions, number of presumptions. So explain any 4. Here also you can write 4 or maximum one more point extra 5. So presumptions we have already discussed. See, this is also very direct question. There is nothing to think or anything. Just if you remember the presumptions, go on writing the points. So it's like I'll give you two or three points, like words in a statute are used precisely and not loosely, and mens rea is required for a criminal act, and then natural justice is a doctrine for interpretation of statutes. So these things, and the legislature knows practice of executive and judiciary. So these things, any 4 they have asked, so you can write maximum 5 and you can end the answer. So this is with respect to your 4th question. See, now coming to the 5th question, here if you see, there are only 2 questions. Each question carries 8 marks. So here you need to elaborate your answer. So you need to write little what do you call it, like extra points, because the question contains this question is for 8 marks. First one, elaborate the offenses relating to computers and connected matters therein. See, this is very easy question, correct? This is like section 65 to 78. So we have studied so many points. That is tampering with computer source document, whoever knowingly conceals, destroys, alters any information. So all these things you have to write, and computer related, regarding computer related offense, we know that is cyber terrorism, violation of privacy, then identity theft. So all these points, if you explain only, that's all, that is sufficient. So offenses relating to computers and connected matters. So those points, if we have studied so many points, so those points, if you explain, that is more than sufficient. It is for 8 marks. So it's like violation of privacy, and whoever tampers with the source code and all those things we have seen. So what is the offense, like 2 lakh rupees imprisonment, fine 2 lakh rupees. So all these things we have seen. So those things, if you explain, that is sufficient. And section 66 also, that contains the stolen, dishonestly receiving stolen computer resource information, identity theft. Those things if you explain. So basically your answer will be divided into 2 paragraphs. One, you will be writing about the offense and what is the punishment, and then you will be writing computer related offense. The points you have so many points, like 10 to 12 points. Those things you will be writing. Then next, this is also a direct easy question only. See, under the Indian Constitution, Parliament is empowered to make law even on the subjects enumerated in the state list. See, usually what happens, state list, only state governments, respective state governments, they are having a right or the power to pass the law with related to those matters. But under certain exceptional circumstances, even Parliament can interfere in state list. So what are those? So discuss the power of Parliament to make laws on state list. So this is again a direct question. If you remember the points easily, you can write the answer. So that is section 249, 250, all these things, if you remember, that is in the national interest, or when there is a emergency is declared, proclamation of emergency, and breakdown of constitutional machinery, then on the request of 2 or more states. Then the last one is legislation for enforcing the international treaty, international agreement. So only under these 5 circumstances or 5 situations, that is basically exceptional circumstances, Parliament can interfere in stateless subject and it can make laws. So only these 5 points, if you properly explain and write, that is more than sufficient, and you will get some like 6 to 7 marks easily you can score. So these 2 questions, if you see, they both are easy. Even though it is for 8 marks, it is very easy and you can easily score. So that is your 5th question. Coming to the last one, that is you can answer 6 or 6A. Again, you have an option here, you have a choice. Either set 6 you can answer, set 6A you can answer. So 6A again has 4 questions, and question number 6 has 4 questions. So whichever set you want, you can choose and you can answer. So first we will see question number 6 ABCD, and then we will go to 6A ABCD. First question number 6. Administrative law is the byproduct of ever increasing functions of the government. Now states have no longer policies limited to maintaining internal order and external threats. Examine. So what this question is all about, it is about administrative law. So you have to tell them that first we will try to understand what they are asking. So here they are trying to tell the state is no longer related, or the state is no longer limited to maintaining internal order and external threats. So state, that is our government and government departments, they are not only concentrating on only maintaining public order. So order, peace in the country, peace in the state, it's not just that, they are having some more functions to perform. So that is why we have administrative law. So what are those functions? Apart from maintaining internal order and external threat, what are the other functions they can perform? See, government is having the educational institution, government is running hospitals, healthcare. So all these are what, apart from maintaining public order, they are also doing all these other functions which both private parties and the government is doing. So government hospitals also we are having, private hospitals also we are having, government schools also we are having, educational institutions, private educational institutions also we are having. So because of that only administrative law has come into existence. Day to day, so many functions government is performing. Because of that, we are having administrative law. So these things you have to write and tell. Because of that, now administrative law has come into existence. So those things you need to write. So I'll just read out few points. With depending on that, you can you get an idea as to how to elaborate the answer. So administrative law, first you write whatever is given. Administrative law is the byproduct of every increasing functions, that thing. And then with the rise of political consciousness, the citizen of a state are no longer satisfied with the state's provisioning of traditional services. The modern state is therefore striving to be a welfare state. That means as citizens, we don't, we are not satisfied with the traditional services. That is like, maintaining peace and order in the country. The only that much we are not happy with that much. So we need something more. Okay. So that thing you have to write. Then it has taken tasks to improve social and economic conditions of the people. It involves undertaking a large number of complex tasks, and development produces economic and social changes, and it creates challenges in the field of health, education, pollution, inequality, etc. And these complex problems cannot be solved except with the growth of administration. So there are so many things. So we need to have administration. So because of that, states have also taken over a number of functions which were previously left to private enterprise. All this has led to origin and growth of administrative law. That means what majorly what we are supposed to write, our government is not concentrating only on providing traditional services like maintaining law and order in the country, peace in the country. Not only that, our government is also concentrating on providing the services. Previously, these services were provided only by the private people. That is like educational institutions, hospitals and all those things. But our government is also providing, along with the private people, government is also providing all these services, all these facilities to the people. So this is welfare state. So to make it as a welfare state, they are providing all these services. So when they're providing all this, and they're giving all these facilities and providing all these services, we need administration. For that purpose, we are having administrative law. So that answer is expected from you. That is 6A. Then next we will go to 6B. That is a managing clerk of a firm of solicitors while acting in the ordinary course of business, committed fraud against a lady claimed by fraudulently inducing her to sign documents transferring her property to him. So that means fraud means what? Immediately you should know this is related to IPC. So he had done so without the knowledge of his principal. Explain the principal will be liable. See, this is fraud means we all know this is it is an offense. So that much you have to write. You have to write 1 or 2 lines about the fraud, and then you are also writing about the principal and principal and agent relationship. So those 2 things you have to remember. First thing you are explaining, just write about fraud. So it is an offense and all those things. That much you have to write, and then now you are writing about the principal and agent relationship. So that is, if you remember, we have seen in tort, he who acts through another is acting himself. So that the act of an agent is the act of principal. So first you are writing what is a fraud. So fraud, first you have to tell it is an offense, correct? That you have to tell. And then you have to talk about principal and agent relationship. So that is about this, vicarious liability and all those things you have to write. So when an agent commits a tort in the ordinary course of his duties as an agent, the principal is also liable for the same. So what you are writing, you're ending the answer telling a master is vicariously liable for the tort of his servant, principal for the tort of his agent, and partners for the tort of a partner. These 3 situations we have already discussed about when it comes to vicarious liability. These people are vicariously liable. Who? Master and master is vicariously liable for the tort of his servant. Master and servant, principal and agent, partners. So this is known as vicarious liability. So that means wrong committed by one and another person is also held liable for it. So you are talking about vicarious liability. You are also talking about what is fraud. Okay, so both the fraud, forgery, whatever, this one or 2 lines, just explain about what is fraud, and then you start explaining about this principal agent relationship, vicarious liability, everything. So here basically we are telling yes, principal is also liable. So principal is also liable, agent is also liable, vicarious liability. So those things, first you have to explain about fraud. Immediately you start explaining, you come to tort and explain about those 3 situations. That is, just give an idea, like in case of partnership, partners are vicarious, other partners are vicariously liable. In case of principal agent, principal is vicariously liable. In case of master and servant, master is liable. So that vicarious liability you explain a little bit and end your answer telling yes, principal is liable in this case. Then next we will go to 6C. That is, what is the effect of acknowledgement? See, this is very easy or a direct question. Acknowledgement, section 18 of Limitation Act. So what is the effect of acknowledgement on the period of limitation under section 18 of Limitation Act? So what is an acknowledgement? So in writing, if you write an acknowledgement means you are giving an acknowledgement or you're giving a guarantee that yes, I owe you this much amount of money. See, you need not even tell when you are paying and all those things. You're just admitting your liability, telling that yes, I have to pay you money. That itself is sufficient. In writing, if you admit your liability, that is considered as acknowledgement. So for that, few points are there which we have discussed in class. It's just that it must be in writing, and it must be in respect of any right or any property, and acknowledgement must be made before the period of limitation, okay, before the expiry of the prescribed period of limitation, and it must be signed. So all these things, if you write these 4 points, you get marks. So that just they are asking about the acknowledgement. These are the 4 important points about acknowledgement. It should be in writing, it should be signed, it should be related to some right or property. That is, you are admitting your liability. Okay, other person is having a right. So you are admitting your liability and you sign. So that much is sufficient. That person gets an extended period of limitation. That much about acknowledgement. Important points you need to write. Then next one is, what is temporary injunction under CPC? Under what circumstances it can be granted? So temporary injunction is when the case is going on for some period or till further order of the court it can be issued, and you need to explain. Okay, first you need to explain what is temporary injunction, and then you have to write under what circumstances. So 1 mark will be given for your explanation about temporary injunction, and then 3 points under what circumstances it can be granted. So that is what circumstances. 3 points are there. If you remember, we have already discussed. First one is that any property in dispute is in danger of being wasted or damaged. So that point you have to write. Then second one is that the defendant threatens or intends to remove or dispose of the property with a view to defrauding the creditors, or it can be that defendant threatens or disposes the plaintiff or otherwise cause injury to the plaintiff in relation to any property in dispute. So these are the situations or circumstances under which a temporary relief or temporary injunction can be granted by the court. So that is, court should feel or you should prove to the court that if the injunction, that is stay order, is not granted, it's going to harm or cause an injury to the plaintiff. Okay, so those things you have to write. That is also a direct question only. And then we will come to the last part or the last question, that is 6A. So this is an alternative question. If you know 6, you can write that only, or you can select this. First one, 6A, first question. Define criminal breach of trust. See, this is also a direct question. Criminal breach of trust 405 of IPC. State the essential ingredients of the offense of criminal breach of trust. So it's directly they are asking about criminal breach of trust and essential ingredients. So first you are writing one paragraph, you are explaining what is criminal breach of trust. So that you have to write up. So that is whoever being in any manner entrusted with property, dominion over property, dishonestly misappropriates it. All those things you need to write, and then you have to write the 3 important ingredients or essential ingredients of criminal breach of trust. That is, accused must be entrusted with the property or should have dominion over it, and the person so entrusted must dishonestly should misappropriate it, and the accused must dishonestly use or dispose of that property. So all these things are there, no? Those points you need to explain. So that is direct question again. Then next one is discuss the power to issue order in urgent cases of nuisance or apprehended danger under section 144. So you can, this is also a direct question wherein you can go to executive magistrate, so you can get an injunction, or in case of emergency they can even pass ex parte order, so it will be valid for 2 months to 6 months. All these things, a whole paragraph we have discussed with respect to section 144 of CRPC, that if you write it as it is, you get marks. So that is also a direct question. Then extrajudicial confession. See, if you remember confession, there are 2. Okay, judicial and extrajudicial confession. Here they are asking about extrajudicial confession. So we will read the question. Extrajudicial confession was made before a witness who was a close relative of the accused, and the testimony of the said witness was reliable and truthful. Examine the relevancy of this confession. See, this is judicial confession and extrajudicial confession. So here what you have to write is, first you need to tell there are 2 types of confession. Okay, first you have to tell there are 2 types of confession. One is judicial and one is extrajudicial. So judicial confession is made before a court or recorded before a magistrate. Okay, that much you write, one sentence. Now you come to extrajudicial confession and little elaborate your answer, because the question is all about extrajudicial confession. Okay, so little explain more about extrajudicial confession. So what you are writing here, extrajudicial confessions are those which are made either to the police or any person other than judge and magistrate as such, and an extrajudicial confession can be relied upon along with other evidence, and it will have to be proved just like any other fact. So you can tell like extrajudicial confession can also be relied upon, but like any other fact, how we prove the facts, no, just like any other fact, if it is proved, if it is reliable, definitely it can be taken. It can be considered as an evidence, and the value of the evidence depends upon the truthfulness of the witness to whom it is made. So these things about extrajudicial confessions you have to write, and you have to write in one of the case law, that is Ram Khilari versus State of Rajasthan. So if you remember the name, you can write. Otherwise, you can write in one of the case law. Supreme Court decided that where an extrajudicial confession was made before a witness who is a close relative of the accused, and the testimony of the witness is reliable and truthful, then extrajudicial confession is proper. Okay, it is taken as an evidence and it is relevant. That much you can explain. And in the given case, so they are given not extrajudicial confession was made before witness who was close relative and all those things. So in the given case, it can be taken as a proper evidence and it can be considered. So that much you have to write. So first paragraph, you are telling confessions are of two types, judicial and extrajudicial. Then you are telling what is judicial, and then start judicial, just write one sentence, that's all. Okay, don't write too much about judicial confession, because here the importance is given to extrajudicial confession. Next, you come to extrajudicial confession, explain about what is extrajudicial confession and explain this case law, this is what has happened. And as per the given question, or as for the given situation, this can be considered as a reliable evidence, or it can be considered as relevant. So something like that you can write and conclude your answer. So therefore, in the given situation, the extrajudicial confession may be considered as relevant, because they are asking relevancy of the confession. No, write the same word only you write. It is considered as relevant. Next, last question. What are the ways in which arbitral proceeding is terminated? So this is also a direct question. What are the ways in which arbitral proceeding is terminated under the Arbitration and Conciliation Act? Explain. So when and how it will be terminated. So first thing, we know how it will be terminated by final award of the arbitrator. Correct? No, by the final award or order of the arbitrator. So next, so the arbitral tribunal shall issue an order. First paragraph, what you are writing, arbitral proceeding will be terminated by final award or order of the arbitrator. Order of the arbitrator can be anything. Correct? No, there are three situations. What is that? The first one can be claimant is withdrawing the claim. Then the second situation can be the parties agree on termination of the proceeding. Parties are only agreeing to terminate the proceedings, or the arbitral tribunal finds continuing of the proceeding has become impossible or unnecessary. So these are the 3 points under which, these are the circumstances under which the arbitral proceedings will be terminated. So it can be terminated either by final award or arbitral tribunal award. Final award or arbitral tribunal order. Order can be any of the three. That is, claimant is withdrawing his claim, or party is only deciding to terminate, or maybe arbitral tribunal finds it unnecessary or impossible. So these 3 points you have to explain. So it is totally 4 points. So this is the answer is expected from 6A4. Okay, so this completes the discussion, a detailed discussion on June 2021 JIGL paper. So if you have any doubts, you can text me, and you can WhatsApp me, or you can send me a message on Telegram. So I'll clarify. So I wish each one of you all the very best, and thank you so much.